Welcome, everyone. I'm Ashley Jones, Vice President of Communications for the Ultimate Asset Protection Structure. I want to thank all the real estate investors from around the country for joining us today. We have a variety of experience on the webinar, from flippers to wholesalers, landlords, and commercial real estate investors. And I also want to have a big shout out to our brokers and agents who are joining us and who want to share this strategy with all of their clients who are investing in real estate today. We're going to give you a priceless strategy to protect not only your personal property, your business, and all your other real estate investments. Yes, that's right, under one simple strategy. For the next 50 minutes, you will, with our team's trusted Bob Bloom, learn a lot. Bob Bloom has been an attorney for nearly 30 years and is one of the nation's leading asset protection strategists. Bob spent several years as a trial lawyer and has represented in court a number of Fortune 500 companies, as well as smaller privately held businesses and real estate investors. Having seen firsthand how devastating a lawsuit can be, Bob turned his attention to protecting people and their businesses from the threat of litigation. As a speaker, Bob has shared the stage with notable political figures such as President Clinton, President Bush, Margaret Thatcher, Mikhail Gorbachev, and financial figures such as Donald Trump, Jim Cramer, David Bach, Susie Orman, Robert Kiyosaki, Rick Brown, and even Sharif Medawar. He is the author of several articles on asset protection, and it is an important contributor to the Asset Protection Handbook that many of you may have and have studied. Bob will share his years of insights into how you can protect yourself from lawsuits to help grow your wealth more quickly and securely. On today's Ultimate Asset Protection webinar, please have a notepad near so you can write down a lot of notes about the structure as Bob presents it. This structure is not presented on any platform in the nation, and I challenge you to find any other structure that is as simple, as inexpensive, and as safe. And now, I present to you Mr. Bob Bloom.
Hello, everyone. My name is Bob Bloom. I'm an attorney in Dallas, Texas, and we are going to be talking on this webinar about the ultimate asset protection approach for property flippers. I assume that I'm talking to many of you who are property flippers, and the process of flipping, for those of you not familiar with it, is those who purchase a property, hopefully undervalue, and find that there's some rehab to do to bring the property up to a much greater value. And so during a process of maybe 2, 3, 4 months or so, we rehab the property, bring it up to after repair value, and are able to sell it at a much higher cost than we purchased it for in a relatively short period of time, and that is considered flipping. So I assume that's who we're talking to, and for property flippers, you have some very good opportunities, but we have to be aware of some pitfalls as well. In every endeavor, there's an offense and a defense. And offense is whatever you do to make money, and certainly that is property flipping. We can make a significant amount of money in a short amount of time by flipping properties. What I'm going to talk to you today about is defense, and that is keeping the money you work so hard to make. And in order to keep the money, we need to be able to protect ourselves against liability. And the biggest threat in terms of liability is lawsuits. Now, when we're talking about real estate, I want you to understand that a lawsuit can start from virtually anything. It can be an accident on the property, it can be a contract dispute, it can be any number of things. But one of the most surprising things to a lot of property owners is how exposed they really are in terms of just about everything, not only liability, but how much people can know about what you're doing. So for instance, I want to give you a quick little overview of the lawsuit situation we have in our country and ask you a few quick questions. For example, if you asked yourself, are lawsuits more common today than they were 40 years ago, I think you'd have to say, yeah. Are there more things you can be sued for today? And I think the answer is clearly yes. Are the damage awards bigger than ever? And the answer is, yeah, they are. And is this trend likely to continue? And I think that's an unqualified yes as well, as sad as that is. Now, the question becomes, why are there so many more lawsuits? today? And there are many, many answers to that question, but one very significant answer is the internet. When Al Gore invented it, lawyers figured out how to jump all over the internet and figure out how to use it to sue people. And so has anybody seen this on the internet? It's a very prominent site. Another internet site is how to sue your landlord in small claims court, suing a landlord in 7 steps, and then one of my favorites is Sue Easy, Take the Power Back. And this is just a very small sample of many, many internet sites out there, typically sponsored by lawyers who are looking for people wanting to sue and encouraging people to sue. Now, to understand how to protect yourself from a lawsuit, we need to understand the dynamics behind a lawsuit. And of course, if you want to cut to the chase, it's all about money. And so, of course, someone who's injured, whether physically or financially, they go to a lawyer and they say, I want to sue. And the lawyer looks at the case very quickly, determines there's some plausible way that they could win the case. It doesn't have to be a hands down, winner, just some arguable way they could win. And the lawyer says, I'll take your case on a contingency fee basis. A contingency fee basically means the lawyer will invest in the case, put up all the money, pay all the fees, all the court costs, and then assuming they win, the lawyer will take 30 or 40% of everything they collect, sometimes higher. So the lawyer gets paid contingent on winning. Now, what that means for the plaintiff is they've got no skin in the game. And they've got no reason not to sue, because if they lose, they walk away, and it's no skin off their back. On the other hand, if they win, it could mean a lot of money to them. So they've got literally nothing to lose, and so they say, let's sue. Now, on the other hand, when you're the one sued, you will never get a lawyer to take your case on a contingency fee basis. You will be paying hundreds of dollars per hour to defend yourself. So right from the get-go, the deck is stacked against you. Contingency fees are only on the plaintiff's side, all right? So once the plaintiff gets the go-ahead or gives the go-ahead rather to sue, the plaintiff's lawyer has to make sure it's a good business decision. In other words, that they're going to get a return on their investment in the case. And so the lawyer will hand your name to a legal assistant and say, go to the internet and do an asset search. This kind of site didn't even exist 10 years ago before broadband exploded, but there are hundreds of these sites now. And here's a typical assignment. It says this site provides detailed financial information to assist attorneys and clients in determining the economic viability of litigation, which means in plain English, how much money do you have that we can take from you if we win? It goes on to say, we offer comprehensive assets searches in the U.S. and over 200 countries of the world. We identify your bank accounts, your brokerage accounts, your real property, vehicles, watercraft, aircraft, business affiliations, and other valuable assets to satisfy judgments. So if you own it, they will find it. Now, once they see you have something, they want to know, okay, well, how much? Because they need to know how much time and effort to put into this case. This next site will tell them every piece of real estate you own, when you bought it, and what you paid for it. In addition, they'll find all your buddies from jail, every place you ever lived, your social security information, your current address. And once they have your current address, they'll go to a free website called Zillow.com and find the county appraised value of your home. Now, they don't care what the county thinks your house is worth, because what they're trying to get at is how much equity do you have in your property. And the reason they want to know how much equity you have is that's exactly what they can take. And so that's what this next site will give them. It includes a real property equity assessment, because this is all public record. Now, it's always been public record, but the difference is in the past, prior to broadband, prior to the internet, they had to go to this office, this county, that state. It took too much time and money, and they didn't do it. But today, with a few clicks of my mouse, they're going to know more about your finances than you do. So most people have no idea that they are that exposed, that people can find how much they own, what they own, and they end up feeling extremely vulnerable, which is exactly what you are, is extremely vulnerable when this kind of information's out there. Now, there are simple and very inexpensive ways that we can change this picture completely, so that even though you own property, even though you have money, when somebody does an asset search on you, you will look broke. Now, you may be thinking, well, I don't want to look broke. No, online, you definitely want to look broke, because when some lawyer is looking at what you have and it comes up zero, the next question in their mind is going to be, well, what's 30% of zero? Yeah, zero. What's in it for me? Why would I waste my time and money going after this guy if there's no payoff at the end of the day? And so if you look broke, it is very, very unlikely that anybody is ever going to want to sue you. I hope that makes complete sense to everybody here. All right? Now, as I mentioned, I'm going to show you a very simple way that you can end up looking flat broke and removing any incentive for anyone to sue you, because understand, it is equity that the plaintiff wants. They are after your equity in the property. All right? So let's talk about how flippers, property flippers in particular, end up getting sued. One of the biggest ways is because you end up doing business in the wrong form of doing business. I hope everybody understands you really don't do business on a handshake deal these days. You don't do business in your name. We're going to talk about that as well. We're going to do business in an entity of some kind, and we'll leave the specifics alone, but the bottom line is this. Look, if you're doing business simply as a partner in a general partnership, and people say, well, what do you mean general partnership? I didn't sign any papers. You don't have to sign any papers. All you have to do is just be in business with somebody else, and you're in a general partnership by default if you have not set up some kind of an entity in which you are both members or shareholders. Now, the bottom line is this. Real estate in particular is an area where people partner very frequently. You may have a money partner, you may have a couple of different people going in together to pool their resources, to buy the property, to rehab the property. Oftentimes I see one person's the money partner, the other person is the contractor. There are loads of different arrangements in which you can end up in a general partnership. Here's the problem. If you're a partner in a general partnership, you have unlimited personal liability for the debts of the business. You can go broke for what your partner does wrong. So I hope nobody on this call is doing business on a handshake deal. You enter into some formal agreement where it is absolutely clear you are not in a general partnership. All right? One other big problem is insurance may very well not cover you. One of the issues is inexperienced people often do not check to see if your contractors are bonded, insured, in other words. Now, they will often say, well, yeah, of course we're insured. And you never check because you're not experienced, and they're not, in fact, bonded. Maybe they're showing you a certificate that is expired. You don't check it carefully. You know, a lot of times these contractors just plain say they're bonded. They're not. And there's a slip and fall on the property. They turn around, they've got no other financial recourse, and they end up suing the property owner. And the bottom line is, you may think, well, I got insurance. Well, good for you. The problem is this. The average damage and award in this country in recent years has tripled to about $1.2 million as reported by Forbes magazine. Now, the average premises liability coverage is capped at about $300,000 to $500,000. Let's assume somebody gets hurt on your property. The jury returns an award for $1.2 million, the average. Your insurance company pays the first, let's say, $500,000. Does anybody see a problem? You could be going broke, even though you have insurance, when juries add zeros to damage awards. And the bottom line is this: even if the insurance coverage is there, it may not be enough to cover you. But very often, the insurance company simply declines coverage. They decline the coverage, and you're left holding the bag. Now, bottom line is, there's an old saying that says insurance is a little bit like a hospital gown. You only think you're covered. And that's really a problem I've seen over and over again in 30 years as a lawyer. All right, now, one of the big questions is this: how do you hold title when you purchase that property that you're intending to flip in 2, 3, 4, 5, 6 months? How did you purchase the property? Well, the common ways that people purchase the property is in their name or in joint ownership with someone else, too often their spouse, or in an LLC or a corporation, or maybe a limited partnership of some kind. Bottom line is this. Bottom line, think of this. If you own the property in your name and something goes wrong, someone's injured on the property, tell me quickly, who gets sued? You get sued. Why? Because you're the owner of the property. Let me give you an example. A little while ago, I ran into a guy and he said, I own 25 rent houses. What do you think of that? And I said, well, that's good. I said, but how do you own them? And he said, well, in my name, but here's the problem. He said, last week, the police raided one of my homes. He said, it turned out one of my renters was running a meth lab in the back bedroom. He said, if this dirtbag sold this junk to some kid and hurt a kid, could they sue me? And the answer is, you bet they can sue him. And when they do, they can take all 25 rental homes potentially. They could take his home potentially. They could take his life savings potentially. He could lose it all because he had, for a legal structure, all of his eggs in one basket. In other words, he was the owner of everything. The problem is, if you own the property in your name, you are responsible for what happens on the property. They sue you, the property owner, and they can take literally, potentially everything you own. So do not take title in your name. One of the best things I can tell you. Second thing, so owning an asset in your name is unbelievably dangerous. You are simply the liable party if the property is in your name. Another way people hold title is in joint ownership. You know, the traditional way to own assets is with your spouse, share alike. And there was nothing wrong with owning your assets with your spouse or a parent, a child, a sibling, a friend. There was nothing wrong with that until June 26, 1985, when the U.S. Supreme Court changed the law by ruling that if you have a joint owner who does something wrong, you can now lose every asset you own jointly with your joint owner, even though you did nothing wrong. So understand, joint ownership does nothing to protect your assets in 2014. It once was a good way to own assets, but no longer. And so the bottom line is, joint ownership is twice as bad as owning assets in simply your name. Get out of joint ownership. Do not take title that way. Now, once again, if you're doing business with someone unrelated to you, not a spouse or parent or child or somebody, you are now in a general partnership. So even worse to hold title with someone else, just jointly speaking. Do not hold title in joint ownership as a general rule. If you're a little more sophisticated than most, you may have taken title to the property in an LLC or a corporation. And while that is one step better than owning it in your name or in joint ownership, it is still not going to give you a lot of protection, not the protection you think it will give you, because you must understand the difference between an outside versus an inside lawsuit. Now, an outside lawsuit, and these are terms that lawyers will use, but you need to understand them, is this. An outside lawsuit means that you, let's say, have a property that you're rehabbing owned by an LLC. You're driving home one day and you get into an accident, and the person ends up suing you who you've injured. Well, that lawsuit or that accident had absolutely nothing to do with anything in the LLC. And so your use of the entity, an LLC, creates a barrier between you and the lawsuit and your assets in the LLC. And so they do not get anything in the LLC. So understand that an entity protects against outside lawsuits. This is why we use entities. In other words, they sue you, you don't own the property, the LLC owns the property, and therefore the property is protected against your personal lawsuits. Okay? Now, on the other hand, an inside lawsuit is completely different. An inside lawsuit basically means there's been an accident on the property. You've got contractors on the property, subs on the property. They're in dangerous situations. Accidents happen, especially in these situations. This is one of the most highest liability situations that you're ever going to encounter as a property owner. And because of that, let's assume that there's an injury on the property. One of the guys gets hurt working on the property. Now, they turn around and sue the owner of the property. Who's the owner? The LLC is the owner of the property. And because they're suing the LLC, they can take everything in the LLC. So understand that when there is a lawsuit against the LLC, you can lose everything in the LLC. An entity, such as an LLC or a corporation, cannot, does not, never will protect against inside lawsuits. And this is a very big surprise to many, many people, because they think that by simply setting up an LLC or a corporation, putting the property in it, or rather taking title to the property when you buy it in an LLC, protects them from everything. Correction, it protects you from outside lawsuits. You can still lose the property in the LLC or the corporation or limited partnership. And so for that reason, and many people don't know why this is done, they just know it's done. This is why we often use multiple LLCs to own multiple properties. It is because we're trying to protect against inside lawsuits. Now, if there's a lawsuit against one LLC because of an inside lawsuit, they can take that one property, but you notice we've protected the other properties in the other entities. So using multiple LLCs is an attempt to protect against inside lawsuits. And certainly using multiple LLCs is better than having all three properties in one LLC. But as you can see, you've still lost what can be some pretty significant equity. So how are we going to protect better against an inside lawsuit? And I'm going to show you in just a minute one of the best ways you could ever have for protecting against an inside lawsuit, and in fact, any kind of liability. Remember, it is equity that is what the plaintiff wants. The plaintiff is after your equity in the property. So here's what we're going to do. We're going to protect the equity. And you already can see you cannot protect the equity by just putting it in an LLC, because an inside lawsuit is not going to, an inside lawsuit can end up meaning you lose property in the LLC, you've lost the equity. So here's what we're going to do instead. Let's step back a minute and look at how equity is and isn't there. Let's assume we have a property with a fair market value of $100,000, but the bank has a lien. Really, what is a mortgage? A mortgage is a lien for $100,000. In other words, you have no equity in the property. And in that case, the lien has first claim on the $100,000 of value, and so you end up with no equity. That lien is in favor of the bank. Let's change it a little bit, or rather just illustrate it a little different way and say we have a fair market value of $100,000. The bank has the lien, or a mortgage, in other words, for $100,000, and there's simply no equity in the property. All right? So if somebody sued you and took the property, you would lose nothing. In fact, there would be no incentive for them to sue you and take the property because they would get nothing for doing it either. There's no value in the property. The bank has the $100,000. Now, let's change this a little bit and show you how we can protect this equity better. Let's assume we now have equity of $100,000, not fair market value. This is now a paid off property, and you have $100,000 of equity in the property. Now, let's also go up to the blue circle and say, rather than this being the bank, let's create a brand new LLC instead of the bank. You have to capitalize an LLC, and we're going to pledge the equity in the property, the $100,000, to capitalize the LLC. Now, a pledge is a promise to pay. And what that means, if you're listening carefully, is that will result in a promissory note, which memorializes the promise to pay $100,000. So now the LLC holds a note, a promissory note, worth $100,000 essentially against the property. Now, to secure that note, the LLC places a lien against the asset for $100,000. The result is there's no equity. In other words, the new LLC steps in the position of what was, by analogy, the bank, and now we have claimed the equity of $100,000 in the asset. Now, what does that mean? What it means is that with every one of the assets you have, whether it's real estate, a personal residence, whether it's business assets, whether it's personal property, you can pledge the equity in those assets to capitalize the LLC. The LLC memorializes that with a promissory note and then places a lien in turn against the assets to secure the note, and the result is there is no equity in any of these assets. Now, remember, they are going to do an asset search on you when they're looking to sue you. And if there is no equity in the property because of the liens that are against the property, it will come up 0 in an equity search. That equity assessment will show 0. And remember, the plaintiff's lawyer will be thinking, what's 30% of 0? 0. What incentive do I have to sue? Because it's equity that is what the plaintiff wants. And when it appears there is no equity, and in fact there is no equity, you have now protected the equity in the property. Now, in other words, when there's an inside lawsuit, an entity such as an LLC, a corporation, a limited partnership cannot protect against inside lawsuits, but understand equity stripping does protect against inside lawsuits because there simply is no equity in the property. So what we're talking about by having the new LLC place liens against the property is called equity stripping. We are, in other words, placing a lien against the property, stripping the equity from the property, and thereby claiming the equity, putting a first position lien on the equity so that a subsequent lien holder literally gets nothing. All right, so equity is what a plaintiff wants, and we have now protected the equity. There simply is no equity with all the liens. Now, I do get questions. People say, well, what does that mean if there's no equity? It means you're much less likely to ever be sued. What's the incentive? There's no recovery available for the plaintiff's lawyer. So people will say, yeah, but there's one thing I don't get. Couldn't they just sue me since I own the LLC? And here's the answer. If they sue you as the owner of the LLC, the answer is no. They cannot take what is in the LLC. And people say, well, why is that? And it's because even though you own the LLC, it is a limited liability company. Now people say, yeah, but what does that mean? Well, let me explain the beauty of this particular LLC that I'm going to describe. We're going to use an LLC that was, by the way, first created, the very first state to create it was back in 1977. It was the state of Wyoming. And Wyoming, since then, has been a leader in LLC law. Any innovations with regard to LLCs typically has been led by the state of Wyoming. It has one of the best LLC laws in the country. And so remember, the LLC holds a promissory note. This is the promise that you have made to capitalize the LLC. It is the pledge of equity in the assets that you have. The reason that the LLC protects you as a member of it, meaning they can't sue you and take your LLC, they can't sue you and take what's in the LLC, is because when they sue a member of an LLC, the remedy or the result of the lawsuit is the plaintiff will get a charging order if they win the lawsuit against you. A charging order is essentially a lien against your interest in the limited liability company, and it's a terrible lien. It gives the plaintiff 3 migraine headaches, which they do not want. The first is this: the law says the plaintiff is allowed to get a certain percentage of the assets in your LLC. The exact percentage they can take every time by law is 0. They cannot seize, attach, or levy upon a single asset in your LLC, and that is the law of the land if you use the right LLC in the right state, which we're going to talk about. Second, the law says we're not going to let them take your assets, but we're going to let them take the net income of the LLC that you distribute. Now, I'm going to read to you from the LLC agreement that we have developed over many years. And I'm going to read what's been called one of the most important clauses ever placed in an LLC. Listen carefully, and then you tell me how much of your hard-earned income you will ever be forced to give to someone who sues you. It says, the manager of the LLC shall distribute the net income to each member of the LLC. However, the manager of the LLC does not have to distribute income if the manager decides not to distribute any income. Think about that. That means the manager will distribute no income. It means the plaintiff gets no income. And you've now protected both your assets and your income as a result of the charging order. Now, just looking at that alone simply means there's no incentive for the plaintiff to sue you. They can't get your assets, they can't get your income, but the third thing is by far the best of all. In the year 1977, the IRS issued one of the most famous revenue rulings of all time. It's known as Revenue Ruling 77-137, and this is the tax law of the United States, which basically says we don't care that the winner of the lawsuit was entitled to get money from you, but they couldn't figure out how to get it. They got no assets, they got no income. We don't care. But the IRS says even though the winner of the lawsuit got nothing from you, the winner of the lawsuit still must pay income taxes on the income you never gave them. Think about that. Why would anybody in their right mind want to sue you when you have your assets in your limited liability company with a charging order as strong as this, which means they get no assets, they get no income, and instead of getting your income, they're going to get a tax bill on income you never gave them? Folks, that is the ultimate disincentive for anyone to ever want to sue you. Now, bottom line is this. Here's how it works. When you are the member, in other words, the owner of the LLC, and they sue you, they will get absolutely nothing. You are protected when we use a properly structured, properly drafted LLC in the correct state. All right? So here is an alternative. You can try to protect your assets using multiple interlocking entities, which I have certainly done for people in the past, and there's a time and a place for this kind of a structure. However, the problem is we now have a lot of tax returns to file. We have a lot of administrative paperwork to follow. We have other issues as well. And so and by the way, we're still subject to inside lawsuits. We're doing the best we can to try to protect, but we're still subject to inside lawsuits as a result. A much simpler and just as safe, if not safer, approach is this. We use a Wyoming LLC that holds a promissory note, which is taken as a pledge against equity in your collateral, and this makes it much, much simpler. It is very easy to operate as a result, and very, very inexpensive. Much, much simpler, easier to operate, and much less expensive than the kind of interlocking structure I just showed you. All right, so we have an ultimate asset protection package for property flippers, and I'll show you what this involves. We set up an LLC in Wyoming, which is the first state to create an LLC and has always been a leader in LLC law. We also draft a very, very careful, very particular, unique operating agreement for the LLC. It has keywords all throughout it providing business reasons to exist beyond simply asset protection, and that must be there. So this is not by any means a run-of-the-mill standard kind of operating agreement. You will not find this just somewhere online. Do not think so. You will make only one interest-only payment per year under the promissory note. Very simply done. That goes to, by the way, to your LLC. You have full control to cancel, write off, or subordinate the note, which is the promissory note. So if you want to undo this structure at any time, you certainly can. And 5, there are no ongoing legal fees to maintain the structure, which makes it very inexpensive and simple to operate. So here's what we end up doing. We will provide a custom Wyoming limited liability company for you, and we will also provide that absolutely unique operating agreement with all the key words. That has a $3,500 value because this is very unique and it will be tailored to your particular situation. Third, we will provide custom promissory notes to encumber the property. Every property is going to be different. Every asset is going to be different, so we customize those promissory notes to that particular property. That is a $1,500 value because, once again, this is going to require some very detailed work. Fourth, we're going to provide limited liability company ownership certificates to you, and that's a $500 value. We will provide the liens for filing, and that's a $1,250 value, and then we will provide registered agent service for 1 year. Many people are not always familiar with what a registered agent is, but it's someone in Wyoming who provides an address for you. It is these are typically commercial companies that do this for thousands of other companies, and they will provide any notice to you, forwarding any documents to you that are necessary for you to pay attention to from a legal standpoint. So the registered agent is your legal representative in the state of Wyoming because you'll have a Wyoming LLC to take advantage of Wyoming law. All right? So that will be provided to you for the next year. That's a $250 value. Then we will provide 1 year of hotline support. So if you have any questions at all about what to do, how to do it, we will walk you through, hold your hand as to what to do and how to do it. So we will be there to provide that year of support. And that's a $2,500 value as well. So many of you can realize that this webinar has explained a number of principles that you've always wondered about, filled in some missing gaps, increased your understanding of inside and outside lawsuits. Maybe that was a brand new concept for you, and you realize this is what you need to do. This is the only way we're going to really protect equity against an inside lawsuit. So to review, we'll provide that custom LLC and the operating agreement with all the keywords. We will provide custom promissory notes to encumber the property, provide the LLC ownership certificates, provide liens for filing, provide registered agent service for 1 year, and 1 year of hotline support, which is a $9,500 value. Now, for those of you on the call today, realize you can set up a very complex structure, which will probably cost you quite a bit more than $9,500. Or you can use a much, much simpler approach, which we are discounting today to $4,995. So it's a much, much simpler setup cost, much simpler to operate, much less expensive to operate, and many people absolutely love this approach. So when you have offense, which is property flipping, and defense, which is what I've just shown you, when you put those two together, you have more money, you have financial security, and you finally have peace of mind. You know, one guy summed it all up by saying, you know, the most important thing is knowing that my wife and kids are protected forever. And I think that's really what it's all about. Now, for those of you who would like to get started, I'm going to encourage you to log on to info@cmrei.com or simply call 407-608-5448, and we'll be happy to take care of you. We're going to, by the way, provide a very nice bonus for those of you getting started. We're going to provide a living trust for only $99. And very often living trusts can cost many, many times more than that. We'll ask you to fill out a form to provide us some certain information that we'll need, but that'll be only $99, and that's literally a $1,200 value, if not more. I think it's significantly more than that, but we're going to provide that for $99, and that's simply a service to you for getting started. So I'm going to really encourage you to do that. Now, if you're not familiar with why you'd want to use a living trust, it's because it will avoid probate. And probate, of course, is that process by which you're going to pass your assets on to your loved ones at your passing. And so we want to avoid probate because it's time-consuming, it can be costly, and you're not in control of the assets during the probate process, which can take months and sometimes even years. We simply avoid all of that by using a living trust. It's a wonderful approach. Everyone, in my view, should have a living trust, and this is a great way to get one. Now, we're also going to provide one other bonus for you. I'm going to have 4 appointment slots available over the next couple of days. My normal hourly rate is $400 an hour, and there will be no cost to the next 4 callers for setting up an appointment. So I'm going to encourage you to call now to reserve. I'll be happy to answer any of your questions about this structure that I've described on this webinar. So I'm happy to do that on a one-on-one basis for the next 4 callers who call in. Folks, I'm going to encourage those of you who are exposed, who own properties in your name, who own properties in joint ownership, who are doing business with other people without the proper structures, those of you who even are using LLCs or corporations, and you realize now that the assets in that LLC or corporation are completely vulnerable to inside lawsuits, which are precisely the kind of lawsuits that are likely to arise for property flippers. So I realize that many of you are going to say, this is exactly what I need, so we're going to encourage you to call in, get online, and take action now to protect yourselves and your loved ones and your property. So I want to thank you all for being on this call, on this webinar, and I hope to be talking to many of you in the near future. Thank you.